Hey guys, so we are now going to go through a read through of the motion for summary judgment, the renewed one from TAG. Just before I do, I just want to go across this because an incredible sleuth has uncovered something. So, do we all remember the kickoff there was over the a film by credit that Justin Baldoni was going to put on the film? Blake Lively insisted it had to go. And here's her message to Josh Greenstein saying it's wild. And then attaching an article where she says it's just a vanity credit, blah, 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 blah. And all that pressure to remove the film by credit as well. So I'm just going to bring you all to this. Before I do, I'm going to turn the volume up. Right. Hopefully this will work. But let's share this. I'm hoping the sound works, right? If it doesn't, it is a very short on TikTok, so I will leave a link just in case in the description. Here we go.
But there's this thing called the vanity credit, and it's a film buy. They use it all the time in films. They use D.W. Griffith. I won't go into all of it. Long 100 years ago, used it, and then other people like Peter Bogdanovich really loved it. And it's tough because it's not a film by one person; it's a film by all. We'd be f***ed without Ray Chan. Like what he did, he's a filmmaker. He helped make the film just like everybody else, and that's important to note. Like I do take control of certain things that I'm sure of.
So hopefully you heard that. Basically, what I was doing was just highlighting the hypocrisy. Like Ryan Reynolds in an interview was talking about the film by credit being a vanity thing, and it disregards the efforts of everyone else who worked on the film, etc., etc. And at the very end, it was cut where he was just saying, "And I do take control of things," and then someone cut the video, and then you get the shot of Sean Levy's A Film by Credit from Deadpool and Wolverine. Okay. Right. Yeah, I just wanted to bring you more Ryan Reynolds hypocrisy for the week. Okay. So Lively's response, opposition to Tag's motion for summary judgment, the renewed motion for summary and judgment. It's not too long actually, and it shouldn't be either because it's just one cause of action. Plaintiff Blake Lively respectfully submits this opposition to Tag's renewed motion for summary judgment. And remember, this was Judge Lyman kind of gave the roadmap for this in the order on the original motion for summary judgment. Introduction. Under the best reading of California law, a business entity agent like Tag clearly may be held liable for aiding and abetting PIHA retaliation. Tag's contrary arguments rely on two concepts that are inapplicable here. 1. Limitations on the direct liability of business entity agents for discrimination or retaliation as articulated by the California Supreme Court's decision in Raines. And 2. Limitations on individual liability under the California Supreme Court's decision in Reno and Jones. But Raines is irrelevant because Lively has not brought a direct liability claim against Tag. And to the extent Reno and Jones limit aiding and abetting liability, that is because those cases involve supervisory employees of a dependent employer. Reno and Jones, following Reno, also hold that such employees cannot be held liable for aiding and abetting their employer on a theory similar to the intracorporate conspiracy doctrine, namely that the employer cannot logically aid and abet itself. But that logic does not extend to agents of a dependent employer, like Tag. The doctrine is limited instead to employees, and it certainly does not extend to an employer's business entity agents. Like Tag, because agents, unlike individual employees, can be held directly liable for FIHA discrimination and retaliation. TAG does not meaningfully dispute that legal framework. Instead, TAG's renewed motion rests on a single proposition that a business entity agent can be directly liable for FIHA discrimination and, by extension, retaliation, only when it carries out FIHA regulated activities. And according to TAG, such activities are limited to the traditional activities performed by an employer in an employment relationship. TAG then assumes that a business entity agent can only be liable for aiding and abetting retaliation, where it could also have been directly liable for retaliation under that standard, a misapplication of Reins that finds no support in the logic of Reno. Instead, there would be little need for an aiding and abetting provision if the only entities it covered were also by definition directly liable. But even if TAG were correct that Reins' limitation applies to the aiding and abetting context, TAG would still be liable. As this court has already held, in the conduct in which TAG participated was FIHA regulated because targeting Lively's professional reputation constitutes an actionable adverse employment action. FIHA covers not only employment actions that are reasonably likely to adversely and materially affect an employee's job performance, but also the employee's opportunity for advancement in his or her career. And as this court has already found, Lively has put forward evidence from which a jury could conclude that TAG carried out such actions on Wayfarer's behalf. Thus, TAG's sole argument that it cannot be liable because it did not perform any FIHA-related activities is wrong on the facts and the law. Meanwhile, it is undisputed that TAG, which had more than 5 employees throughout the relevant period, meets the necessary definition of employer. Nor does TAG dispute that sufficient evidence exists for a jury to conclude that it knowingly and substantially assisted the conduct that Lively challenges as actionable retaliation. And even if TAG had disputed that in its renewed motion, the record contains more than enough such evidence. TAG's renewed motion for summary judgment should be denied. Okay, background. The summary judgment record is detailed extensively in Lively's opposition to the motion for summary judgment and in the court's MSJ opinion. Lively summarizes an illustrative selection of relevant facts here, none of which appear to be challenged for the purposes of this motion. TAG is a limited liability company that during the period relevant here has always had more than 5 employees. Wayfarer retained an onboarded TAG against the backdrop of Lively's protected complaints. By the time TAG entered the picture in July 2024, Wayfarer had already received complaints from Lively over a year earlier, in May 2023, received the protections for return to production letter in November 2023, and participated in the January 4th, 2024 all-hands meeting at which Lively identified conduct she regarded as sexually inappropriate and retaliatory. And I still maintain that all-hands meeting, as they keep calling it, was nothing of the kind and was not protected activity, in my opinion. Only Justin Baldoni was invited, was told he could go alone, and there was no indication of what they were going to discuss. There was no formalities whatsoever. It was carried out in Lively's home, surrounded by her staff and her children, and her husband was there as a representative, which in and of itself is not an issue. But, where's the relevant staff? Where's the HR? For all the complaining Lively did about the lack of HR, why didn't she invite a HR to kind of oversee and properly document and minute the meeting, if that's what it's meant to be? Among other things, TAG knew about the anti-retaliation provision in the protections letter and that it expressly prohibited retaliation of any kind for Lively raising concerns and expressly defined retaliation to include any negative behavior during publicity and promotional work. And again, for me, that is far too broad. Like, literally define that. What does that look like? Who's making the assessment? And what kind of, there has to be a balance as well. Like, are we going to say that if someone's having a bad day, that there automatically means that they're retaliating against you? And how long does this go on for? Is it for infinity? That term, so in the CRA, which everyone is probably aware, I hotly dispute that there's even a contract there that Blake Lively is a party to. But that having that kind of term would just render the contract completely unenforceable in the UK, because it's completely unreasonable and unfair. And it would not have any enforceability under UCTA, which is the Unfair Contract Terms Act. After Lively informed Sony in July 2024 that she would not appear in press with Baldoni, another protected form of oppression to a form of opposition to Baldoni's conduct. Again, I dispute. Tara Hanks, the president of Wayfarer, asked Wayfarer's publicist Stephanie Jones for recommendations for a crisis communications team. I'm just going to go back to the refusal to appear in press and what they said about it being another protected form of opposition to Baldoni's conduct. If you're opposing Baldoni's conduct so much that you're not going to actually do your job with him, i.e. the promotion, then why the hell did you go back for phase 2? And if phase 2 was fine, which Lively says it was, then why do you feel the need to take that stance? It makes no sense. The sole purpose of not doing the promotion with Baldoni was to exclude him and to be able to go in there. So she's shutting down Baldoni. He's talking about domestic violence, and now she's the face of the film. She's taking all her minions with her, and then she's talking about her hair care products and her alcohol crap, and her friends, and her friends' songs, and her husband's clothes, and her friends' clothes, blah 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 blah, and all the music. That's why she excluded Baldoni. Okay. Jennifer Abel also asked Jamie Heath to share with her the legal letter that was sent by Lively and her team per our conversation. We'll go through point by point and draft context surrounding each situation. We can then flag what we are missing that would be helpful to arm us in the case. Note the words, in the case. We need to refute any of the claims. It sounds defensive to me. Does not sound like, she's on the attack. Like Wayfarer, are on the attack. I really don't think that's the flex Lively thinks it is. The record also shows that Tag was expressly briefed on the substance of Lively's allegations at the outset of the engagement. On July 25th, 2024, Nathan and Vice President Catherine Case, Vice President of Tag, Katie Case met with Heath and Hanks for an introductory call, during which Wayfarer provided details regarding the protections letter and the incidents to which it alluded. Tag's own contemporaneous notes reflect that Wayfarer wanted a strategic response, confirming that the engagement was framed around taking action related to Lively's complaints, contained in part in her legal letter. After the call, Wayfarer engaged Tag. Days after its initial meeting with Wayfarer, Tag discussed drafting a scenario document that would develop a strategy to desensationalize Lively's story by teeing up a friendly to run of the day of, or right after the premiere, someone who is covering the overall film of Baldoni saying something along the lines of, "Me and Blake had our differences, but I still respect her." So we at least set the stage and can then give the rest on background to reporters. So when the hit piece runs, it's not as big of a shock. Tag circulated its scenario planning document to Wayfarer the next day. That scenario planning document emphasized Lively's less than favorable reputation in the industry and proposed planting stories about the weaponization of feminism to portray Lively and her circle as bullies. Around the same time, Nathan and other Tag employees began speaking regularly on background with reporters, including Tag's friendlies at the Daily Mail, TMZ, and New York Post, while leaving no written trail of what they were telling those reporters as sources familiar with the matter. Abel texted Nathan that she was having reckless thoughts of wanting to plant pieces this week of how horrible Blake is to work with. Nathan responded same and shared that she had already, off the record, spoke to the editor of the Daily Mail because she's my friend and that she's ready when we are. On August 7th, 2024, Brianna Koslow texted JB PR, I'm guessing WO is without JB, group, that we are starting to hear things from our friendlies Daily Mail, TMZ, New York Post. So need to shift messaging and potentially getting ahead of this /baloney item. What? On August 9th, 2024, Nathan successfully convinced the New York Post Page 6 reporter, who is also Nathan's sister, to reduce down language referring to Baldoni as a sexual predator to chauvinistic and borderline abusive. Okay, I don't see any problem with that. Tone down language. Like, there isn't a sexual predator. Even the best reading of Lively's claims, do not suggest that Baldoni is a sexual predator. And that's something that Judge Lyman kind of, indirectly alluded to as well. And Lyman said he was allowed to defend himself. The record shows that TAG knew and understood its work for Wayfarer was in furtherance of unlawful conduct, further evidenced by the fact that it took pains to execute its plans in a way that would be untraceable, without fingerprints, and that could not be written down because of the consequences if its conduct was discovered. For example, after Wayfarer received the scenario planning document from TAG, Baldoni texted Abel that he was not in love with it, adding, not sure I'm feeling the protection I felt on the call. Abel immediately shared this with Nathan, stating, I'm going to confidentially send you guys something he's texting me and Jamie on the side just to arm you before this call. I think you guys need to be tough and show the strength of what you guys can do in these scenarios. He wants to feel like she can be buried. Nathan responded, of course, but when we send over documents, we can't send over the work we will or could do, because that could get us in a lot of trouble. We can't write it down to him. We can't write, we will destroy her. To which Abel replied, of course not, but I told him that's the point of talking through. Nathan then observed, he has to look at it as an information document for us to be armed with. That's all. Imagine if a document saying all the things that he wants ends up in the wrong hands. We can bury anyone, but I can't write that to him. I'll be very tough. Nathan also sent an agenda to Abel for an upcoming call with Baldoni, which included discussing a more aggressive way to get ahead of this. Nathan additionally emphasized to Abel and Heath that all of this will be, most importantly, untraceable. So Gottlieb's just written all of this, and it's just basically chucking in all the contents of the text messages. This is starting to feel like it's just a PR, like, to highlight all the various statements that Lively is relying on. All the various statements that may or may not be, this is without context, really. And it sounds like they've kind of waving the white flag a little bit, because, this is like a Hail Mary PR move now. TAG also operationalized the digital campaign strategy. Baldoni's talent agent wrote in a message that Justin's crisis team was ready for a war with Lively and that they had all kinds of garbage on her. TAG also connected Wayfarer with a digital mitigation firm led by Jed Wallace and Street Relations, describing the firm as capable of narrative seeding, algorithmic influence, content suppression, and online engagement undertaken without fingerprints. TAG engaged directly with social media influencers and content generators to disseminate its messaging. For example, Nathan messaged Perez Hilton that he was in her circle of BF trust. He was a former fucking client of Brian Friedman. and he happened to be a journalist. Of course, Friedman trusts him. And that she would be happy for him to say this, followed by explicit language you can say, to which Hilton responded, "We'll get on these later." Tag also planted negative stories in the media about Lively and Reynolds. In fact, on August 13th, 2024, Coslow texted Case bullet points for a Daily Mail think piece on the whole PR debacle behind the scenes, including talking points such as a film with serious subject matter being promoted with focus on flowers and clothes. Why would Blake allow this to happen? I mean, tell me what's false about that. How could she? What is she thinking right now regarding her team? And did Blake's inability to relate to other people, to regular people / what they want to see, just slight her big moment? Case approved and added that they should bring in the fact that she promoted a hair care line and her own drink brand as part of the promo. Again, point to something here to me that is untrue, that the rest of us did not see. Like, how can you call this a smear campaign? We all watched her actually do this. Later that day, Coslow texted Nathan about this think piece and noted that it would be framed such that it's not so obviously placed, to which Nathan responded, "Yes, let's go." The resulting Daily Mail article, published August 20th, reported that although this should be the crowning moment of Blake Lively's career, Lively has come under fire for aggressively marketing her personal projects. Not just her hair care, but her drinks company, seemingly on the back of a film dealing with domestic violence. Right, this is exactly what, when, they may have been planning some stuff and they may have been strategizing to have a plan in place in case Blake Lively went public with her allegations. Fine. Okay. So the earlier text messages, yeah, I can see that conversation and the relevance there. Planning to do something and actually doing it are two different things. But now they're talking, they're actively having conversations about, oh my God, look at what she's done. Look at how she's promoted this film. And it really does support the narrative, actually, that they had a plan, but they didn't need it in the end because she organically blew herself up. Because they're talking about all the things she did to blow herself up, which we all watched her do ourselves, and we're like, I think everyone was questioning it. And the same thing happened to Colleen Hoover when she attempted to do something almost identical with the nail polish and the coloring books, and she tried to market the book in a very similar tone deaf way, and she received huge backlash. Did she go screaming that it was retaliation or a smear campaign? No. She kind of took it on the chin, apologized, and withdrew the products. In that sense, and only that sense, I have mild respect for Colleen Hoover. And if Blake Lively had just done that, then we wouldn't be here right now. She smeared herself. Moreover, on August 15th, 2024, Nathan told Abel that the Daily Mail was hounding her re-HR complaints. So she deflected by telling them to instead look into how Lively is emulating her best friend Taylor with the charm bracelets and shit. Because it was the only thing she could give off the top of her head that looked organic and wouldn't seem like replaced about the film. Case then emailed the Daily Mail reporter with helpful links comparing Lively to Taylor Swift. Just want to say though, right? The Daily Mail contacting Tag about the HR complaints, that was due to Leslie Sloan planting the suggestion with the Daily Mail. That was Sloan did that, and then obviously they were asked a question. So they were contacted for a response. Case then emailed the Daily Mail reporter with helpful links comparing Lively to Taylor Swift. The resulting Daily Mail article, published August 17th, quoted a source who told DailyMail.com exclusively that Blake has been relying on Taylor to get her through this storm by using their friendship for interviews and other promotional work directly related to the film, and that Lively laughed at the concept of making herself available to domestic violence survivors, showing how out of touch she is. I mean, she did use Taylor Swift, like the whole dragon things for a start. Every interview, she referenced Taylor Swift. Oh, she's been with me all the way through this film. She's everywhere in the film. Oh, I had to work hard to get her song. And obviously the reference to her laughing at herself the reference to Lively laughing at the concept of making herself available to domestic violence survivors is the location share interview. Again, all Lively's own doing, own words, her own interviews, which because she, would not allow Baldoni to promote the film with her, how can she now say, well, he did all this damage to me? She made a point of keeping him away from her interviews and her promotion. So when her promotion now is coming under fire, the one person she cannot point fingers at and say it's his fault is Justin Baldoni. Given Nathan and Case's communications with the Daily Mail reporter, this would be James Vituska, this anonymous source is virtually certain to be Nathan or Case. Again, it's not a smear campaign, though. Linking Blake Lively is not a smear campaign. If that was the case, Blake Lively would have shut up about Taylor Swift a long time ago. On August 15th, 2024, Kozlov spoke to Tatiana Siegel from Variety about an article focusing on the union violations that Reynolds allegedly did commit, by the way, by working on the script during the WGA strike and replacement editors being brought in to recut the... This is all true. Like, Gottlieb's framing this as, oh, this is all, fabricated stories. All of these things are true. I'm getting annoyed, so I'm just gonna take a breath. Okay, right. Kozlov emphasized that the placement would be hands-off and not some bigger takedown which could backfire. On August 27th, Variety published the article reporting that Reynolds' involvement in It Ends With Us raises WGA issues, and that sources say Reynolds writing the rooftop scene came as news to Baldoni. It did! Who thought the scene had been ad-libbed by Lively. It did. She announced it on the red carpet. No one knew about it. She even says, no one else knows this but you. These sources are most likely Kozlov. No, it's fucking Blake Lively was the source. And other tag team members, considering Kozlov had a convo with Tatiana, who was interested in doing a piece on the fact that people are overlooking the violation that occurred. Pointing out that Ryan Reynolds broke the rules of the WGA to write during a strike and is therefore a scab is not a smear campaign. And even if it was, it's a smear campaign against Ryan Reynolds, who did not speak up about sexual harassment in the workplace. So it's not actionable. I don't know why she's bringing in anything to do with her husband. Her husband has fuck all to do with this, despite the constant attempts to make him relevant. These stories, each conceived, sourced, and greenlit by TAG employees, illustrate that TAG actively executed a media campaign targeting Lively's reputation. I'm sorry, if they're conceding that Lively's reputation was damaged by all of that stuff that was happening, then they're basically saying that there is no reputational harm caused by Wayfarer because Lively was an asshole, and the world saw it. And as this court noted, TAG's efforts were fruitful. Expert evidence indicates that the retaliation campaign TAG orchestrated generated a conservative estimate of over 176 million online impressions, branding Lively a bully, mean girl, and tone deaf. Polling indicates a 30% increase in negative attitudes toward Lively from June to September 2024. Honestly, Is that seriously the worst of the insults? You're a bully, you're a mean girl, and you're tone deaf. And she's asking for millions, tens of millions of dollars in damages for this. I mean, it's protected opinion, really, isn't it? It is. How is that any different to to Ryan Reynolds saying that Justin Baldoni is a sexual predator? Except one is worse than the other, i.e., calling someone a sexual predator is a serious thing. Professor Humphreys found that the retaliation campaign promoted specific identifiable frames associated with Lively, and these became widely circulated during and after the period of the campaign. I'm getting annoyed now. Becoming the lens through which the general public integrated new information and resulting in a lasting negative impact on Miss Lively's reputation. And she's just trying to clean up her reputation since the dawn of time. Dr. Maislin similarly observed a marked shift in the volume, the content, and the sentiment of online conversations about Miss Lively, consistent with the onset of defendant's orchestrated campaign. That was just bullshit. All of that was just absolute bullshit. It was nonsense. All he was doing really in that entire section was basically confirming that yes, Tag and Wayfarer may have had a plan in place, right? But they didn't actually use the plan. Why? Because in real time, Lively was committing career suicide with her own actions and her own statements, and she could not blame Baldoni for it because she made a point of refusing to allow him to participate in the promotion with her. That's all I'm hearing. The argument. Tag's motion erroneously applies a direct liability test to Lively's aiding and abetting claim. Tag's renewed motion for summary judgment attacks a theory of liability Lively does not assert. Lively brings a single claim against Tag under the California Fair Employment and Housing Act for aiding and abetting retaliation in violation of Government Code Section 129401. Tag nonetheless frames its motion around whether it can be held directly liable under FEHA, arguing that because it did not hire, fire, supervise, compensate, or discipline Lively, it falls categorically outside FEHA's reach. But Lively does not bring a direct liability retaliation claim against Tag. Instead, Lively alleges that Tag knowingly and substantially assisted Wayfarer's retaliatory campaign by coordinating and executing an astroturfing effort designed to discredit and bury her after she complained of sexual harassment on the set of It Ends With Us. In addressing this claim, Tag's motion conflates direct liability with aiding and abetting liability and asks the court to read limitations into Section 129401 that neither the statute nor the case law recognizes. FEHA's aiding and abetting provision creates an independent basis for liability that does not depend on whether the alleged aider and abetter could be held directly liable for the principal's conduct, and the cases limiting aiding and abetting liability to exclude individual employees acting on behalf of their employer do so for a different reason, akin to the intracorporate conspiracy doctrine. A corporation cannot aid and abet itself. Tag's argument thus appeals to the wrong legal framework. Section 129401 imposes liability on any person who aids, abets, incites, compels, or coerces a FEHA violation. The statute does not ask whether the defendant qualifies as an employer or performed FEHA-regulated employment functions. Instead, courts apply common law aiding and abetting principles under which liability turns on the alleged aider and abettor's knowledge and substantial assistance of the employer's conduct, not on its employer's status or agency relationship. Okay. The California Court of Appeal has expressly rejected the rule Tag advances here. In Smith, the plaintiff asserted an aiding and abetting FIHA claim against the vendor and one of its sales representatives based on racially discriminatory remarks allegedly made during a product presentation to the plaintiff and his co-workers. Neither defendant employed the plaintiff, supervised his work, nor exercised any employment authority over him. They were outside entities, invited to the workplace solely to market their product. Right, but Tag have been invited to, they're not even invited to the workplace particularly, but they've been contracted to help with crisis PR. Although the plaintiff's claim ultimately failed on the merits, the Court of Appeal squarely rejected defendants' arguments that they cannot be liable under FIHA because they were never the plaintiff's employer. The court emphasized that FIHA prohibits any person from aiding or abetting discrimination, and that for that reason, individuals and entities who are not the plaintiff's employer may be liable under FIHA for aiding and abetting the plaintiff's employer's violation. In doing so, Smith confirms that aiding and abetting liability does not depend on an employment relationship or the performance of employment-related functions, but on knowledge and substantial assistance. Likewise, in Alch, the court held that non-employer talent agencies could be liable under Section 129401, where they knowingly use their own practices to assist discriminatory conduct. Other courts have reached the same conclusion for non-employer entities. The Court of Appeal's decision in Alch squarely illustrates the point. There, the defendants were non-employer talent agencies that did not hire, fire, supervise, or discipline the plaintiffs. The court nonetheless held that the agencies could be liable under Section 129401 because they allegedly knew that the studios were engaged in discrimination and used their own referral practices to substantially assist that conduct. Liability turned on the agency's independent participation, not on agency or employment authority. Other courts have similarly analyzed agency liability independently from aiding and abetting. It's just they kind of argued the complete opposite when, Wayfarer used the agent theory for Leslie Sloan and Ryan Reynolds. As I would expect them to do, that is completely what the attorneys are supposed to do, is to argue the position that is best for your client. I'd have to go back to Wayfarer's to Tag's motion for summary judgment just to revisit how, because they used the same cases, and I just want to go back and see how it was framed. Okay, so yeah, I've just had a quick read actually. So in Reno, right, so how Tag approached this was, so the California Supreme Court, and Gottlieb is referring to the California Court of Appeal, right? The Supreme Court is obviously a higher court. And the California treated issues of direct liability and aiding and abetting liability similar. And that is why Gottlieb saying, well, we've not, no one's alleged that there was direct liability, but Wayfarer, Tag actually said in the motion for summary judgment, well, the Supreme Court actually treated them similarly anyway. And business entity agents are only directly liable for substantive FIHA violations when they carry out FIHA regulated activities, which is something that Lively has not alleged, nor demonstrated with respect to Tag. And when they say FIHA related activities, they are saying, well, Tag was not involved in Lively's employment at all. So Lively cannot assert a claim for an employment related violation against Tag. Now, Gottlieb is saying, well, hold on a minute, we've never asserted direct liability. We're asserting aiding and abetting liability. But Tag is saying, well, yeah, but the Supreme Court has already treats that similarly. So that was in Reno. What was the other one? In Reigns, that's it, Reigns. Direct liability under PIHA. Reigns court ruled that as a necessary minimum consistent with PIHA's language and purpose, a business entity agent can bear direct PIHA liability only when it carries out PIHA regulated activities on behalf of an employer. So again, they're saying, well, hold on a minute, Tag was not your employer. Tag is not liable for aiding and abetting a violation of PIHA. And then they refer to ALC, which Gottlieb has rebutted. That was a Court of Appeal decision. That examined whether talent agencies for television writers could be liable for allegedly assisting networks and studios in engaging in age discrimination. Now, the Court of Appeal, in finding that aiding and abetting liability under PIHA could attach to talent agencies, the court held that complaints adequately alleged that the agencies knew the employer were engaged in systemic discrimination on the basis of age and gave substantial assistance or encouragement to such conduct by virtue of their own referral practices. And what Wayfarer, I mean Tag. If I say Wayfarer, I mean Tag, right? And what Tag is sort of saying here is, well, talent agencies have a relationship with, with television writers, in that they refer talent to the television writers as a routine part of their job. They have that kind of very close relationship. Tag, on the other hand, was purely hired for, one job, a one-off job. There is no ongoing relationship with Wayfarer. And in this case, I do mean Wayfarer. There is no ongoing relationship, where Tag would have known, that it was like a course of conduct for Wayfarer to discriminate or retaliate. And that's basically how it's argued. And I have to say, so far, comparing and contrasting, I'm not convinced, because Gottlieb is now trying to say, yeah, we didn't say direct liability. We said aiding and abetting liability. But the law could support both arguments. And this is litigation, right? At its finest, actually, is the cases could support either position. It's all about how you argue them and how persuasive you are. And when I say that 50% of trials, even if you've got good supporting case law and so on and so forth, it's all about how the evidence is presented and how the attorneys argue that the law applies. The moot. When I say that 50% of cases are won because of how persuasive a attorney has been in presenting the evidence and the arguments, regardless of what the evidence and the case law, says, how persuasive they are. I mean it. I'm not persuaded by Lively's arguments at this point, but I'm not going to go so far as to say if you look at them in the light that Gottlieb is asking you to look at them, I'm not going to go as far as to say they don't actually have some support to Lively's arguments here. But I think they are more supportive of Tag's arguments. So let's continue. The cases tying aiding and abetting liability to the possibility of direct liability do so for a different reason. In Reno, the California Supreme Court held that non-employer individuals, specifically supervisory employees, could not be directly liable for FEHA discrimination. Reno further explained that although aiding and abetting liability did apply to third parties such as customers or suppliers, it could not extend to the supervisory employees because that would be tantamount to holding that the corporation had aided and abetted itself. The concept of aiding and abetting involves two separate persons, one helping the other. Here we deal with the individual employees of a corporate employer. A corporation can act only through its individual employees. Our question is whether it can properly be said that a corporate employee is aiding and abetting his or her corporate employer when the corporate employee acts on behalf of the corporation by making a personnel decision, or more precisely, whether this is the meaning intended by the legislator. Reno held that given the oddity of concluding that a corporate employee could have aided and abetted his or her employer by acting on behalf of the corporation, the California legislature would have spoken in clearer terms had it intended that result. Reno thus draws a critical distinction between employee agents who act on behalf of the employer, like individual supervisors, and independent non-employee agents who assist the employer's unlawful conduct. Employee agents acting within the scope of their employment cannot aid and abet their own employer, just as they cannot conspire with the entity that employs them. But outside actors who help another commit a prohibited act may be liable under Section 129401. Any other interpretation would effectively read FEHA's aiding and abetting provision out of the statute. Together, Reno, Elk, and Smith foreclosed TAG's attempts to limit 129401 to actors who can be held directly liable for discrimination or retaliation. To the contrary, only certain specific non-employers cannot be held liable for aiding and abetting. Those who, because they are employees of the corporation in question, cannot conspire with or aid or abet that corporation as a matter of law. TAG is not such an entity. TAG's renewed motion for summary judgment does not address this distinction between direct liability and aiding and abetting liability, merely assuming that to the extent TAG could not be directly liable for retaliation, also an unsupported proposition as explained below, it could not be liable for aiding and abetting retaliation. But that reasoning is unsupported by the logic of the California Supreme Court's precedents, and if adopted, would write the aiding and abetting provision out of the statute. Okay, I mean that's quite a good argument. I have to give Gottlieb his flowers here a little bit. Not a bad argument. Where I do think there is a little bit of a problem, because there was another case that Tag referred to, and I remember it because I couldn't say it, but it was Malik Zadeh. Malik Zadeh. I'm going to go with that. And the same to a point with Alk as well, is Lively is not actually provided evidence that Tag engaged or it directly or indirectly in any employment-related practices. And actually, to the contrary, the evidence demonstrates that Tag simply engaged in public relations work for Baldoni for Wayfarer after Lively's work on the film ended. And there is no evidence that Tag encouraged Wayfarer, which is important, right? You can be hired to do a job, yeah? Think Lively gets a bit confused with this, but you can be hired to do a specific job, i.e., Tag was hired by Wayfarer to perform a specific function, managed the crisis PR, in case something, caused a problem for Baldoni or for the film. But for aiding and abetting, there has to be evidence that Tag encouraged Wayfarer, like literally actively got on and said, you need to do this. And actually, if they're relying on the message from Jen Abel that Baldoni didn't feel protected, it sounds like actually the encouragement didn't come from Tag. It came from Baldoni. So that then weakens the assertion that that Tag have aided and abetted. Yeah. And the thing is, right, it is a FIHA. It is a FIHA statute. So the retaliation comes under FIHA, which is the Fair Employment and Housing. So the fact is, right, is Tag were onboarded after Lively's working relationship had already ended. They did not do anything to interfere or cause any effect to Lively's working relationship with Wayfarer. And if something, if you're relying on FIHA, then I think the question of whether it's employment based or not is rather important, just as important as is Lively an employee or an independent contractor. That's just my opinion. So other lawyers may have a completely different opinion or a different interpretation, but that's how I interpret, because it is a FIHA retaliation claim. Okay, just some thoughts I have there. Let's continue with this though. Even if they applied reigns limited on direct or agency-based FIHA liability would not bar Lively's Section 129401 claim against Tag. Drawing on Reigns, Tag asserts that its liability turns on whether it was engaged in FIHA regulated activities, which Tag defines further as the traditional activities performed by an employer in an employment relationship. As Tag acknowledges, Reigns was a direct liability case. For the reasons discussed above, the limitations on direct liability for FIHA discrimination or retaliation do not extend to aiding and abetting, except in the context of the employees of a defendant employer. Stated differently, Tag's argument depends on an extension of Reigns from the direct liability context to the aiding and abetting context that is not justified by the logic of Reno, which limited the aiding and abetting provisions independent scope for specific reasons that do not apply to business entity agents. But even if Reigns' FIHA-regulated activities limitation applied to Tag's aiding and abetting liability here, Tag would still be liable for the simple reason that the retaliatory adverse employment actions that Tag assisted are FIHA-regulated. In Reigns, the California Supreme Court considered whether a business entity that serves as an employer's agent may be directly liable under FIHA when it carries out FIHA-regulated employment activities on the employer's behalf. The court answered that question in the affirmative, holding that such an agent may be directly liable where it satisfies the statutory definition of employer by having at least 5 employees and performs FIHA-regulated functions for the employer. All the court did was state that Tag would be a FIHA-regulated employer. It did not say that because of that would make Tag directly responsible for Lively's employment-related kind of activities. But he's trying to conflate the two there, and I don't think Lyman will buy that. By the nature of the business, Tag is a FIHA-regulated employer. It has, the minimum amount of employees, etc., and it performs FIHA-regulated functions. But Lively, who is bringing the employment action, was not employed by Tag, and Tag had no relevance to the hiring of Lively. Whereas, when we go back to the television writers and the talent agency case, which was, I think that was Reno. Was it Reno? He's one of them. Yeah, I think it was Reno. When we go back to that case, that's the whole point, right? Is that the talent agencies do have a direct effect on the employment of the employees, people who go on to be employees of the television writers. So it's a different scenario that does not apply to TAG. I'm trying to show a little bit of how how you kind of how two counsel take one case and make it distinct in circumstances. I hope it's making a little bit of sense. In Reigns, the California Supreme, no, I've read that, but critically, Reigns did not interpret Section 129401, but it did not analyze aiding and abetting liability. It did not purport to limit the reach of FEHA's aiding and abetting provision. To the contrary, the court expressly reserved the scope of a business entity's agent's possible liability under FEHA's aider and abetter provision. TAG's motion omits that reservation while attempting to extend Reigns' direct liability principles into a statute the court did not construe. Activities that constitute actionable retaliation are FEHA regulated, as relevant here, and as this court has already held, FEHA covers not only employment actions that are reasonably likely to adversely and materially affect an employee's job performance, but also the employee's opportunity for advancement in his or her career. Right. She's not said that. She's not made that argument, really. She's now making it as part of her damages thing, like, oh, well, I've lost all these opportunities. But she hasn't really explained what opportunities she has lost. And as this court has already found, Lively has put forward evidence from which a jury could conclude that TAG carried out such actions on Wayfarer's behalf. Indeed, the bulk of the court's discussion of the actionable retaliatory conduct in this case involves conduct that TAG substantially assisted. I mean, yeah, that's a fair point. I'm not gonna quote that because that's from the that's from the judge's opinion. It's basically saying, well, TAG did this and the jury could reasonably believe TAG did that. But it also mentions Abel, who has been dismissed, and it mentions Nathan, who has been dismissed. It is settled that Lively has presented sufficient evidence for a jury to conclude that the precise conduct TAG substantially assisted constituted adverse employment action under FEHA. Thus, it is also settled that the activities on which the aiding and abetting claim against TAG is based were FEHA regulated. Finally, defendants submit that the court should not create new law for the state of California. But when a federal district court is confronted with an unsettled question of state law, it is the court's job to predict how the forum state's highest court would decide the issue. Principally, a court does so by considering the language of the state intermediate appellate courts as well as the language of other jurisdictions on the same issue and other sources the state's highest court might rely upon in deciding the question. Okay, I will say he's made a fair point there, right? If the situation is unsettled, then yeah, absolutely. But where he is contradicted himself here is by pointing to the statute and then saying to Wayfarer, you're making arguments that the statute does not make. You're trying to expand upon the scope of the statute. But likewise, for not Wayfarer, sorry, TAG. Likewise, for TAG, the situation is not settled, right? So if the statute suggests and refers to direct liability, or it doesn't, whatever way, and they're bringing this case, and it's a case that has not really like it's got some points in it which could go either way, then Wayfarer need to make the argument, because it may be that the judge agrees, and then the argument then starts to apply to aiding and abetting liability. It may become a binding precedent, and Gottlieb's right. The way that these things normally take place is the statute is enacted, someone goes to court, brings a claim, and it's got some quite niche circumstances, and one side will argue, well, the statute was not intended to apply to that. The other side will say, well, hold on a minute, there's nothing that says it couldn't apply to that. Judge, what do you think? Or jury, what do you think? And then a decision will be made, and that decision will be binding, and it will either limit the scope of the statute to the issue, or it will expand it to include this niche issue that was brought up at trial. That's how these things happen. So, it's quite interesting to see, on the flip side, Gottlieb saying, well, no, Wayfarer, no, you shouldn't be, the statute doesn't cover, the statute doesn't limit to direct this, or it doesn't cover that. But then, he's saying, well, hold on a minute, Judge Lyman, don't listen to them asking you not to create new law for the state of California, because that's what a court is supposed to do. So, yeah, he's right though. But he just he doesn't like it when Wayfarer say it. Here that task is straightforward. California's appellate courts treat FIHA aiding and abetting as an independent source of liability, regardless of the aider and abettor's status as an employer or participation in FIHA-regulated activities, and the logic of the California Supreme Court precedents ruling out aiding and abetting liability for supervisory employees does not extend to business entity agents of the employer. Meanwhile, retaliatory adverse action, such as disseminating negative information to harm a plaintiff's reputation, is actionable under FIHA. The California Supreme Court would be highly likely, but not guaranteed because there's no precedent, to conclude that a jury could find TAG liable for FIHA aiding and abetting under these circumstances, and this court should therefore do the same. TAG does not dispute the elements of aiding and abetting. TAG's renewed motion does not dispute that TAG knowingly and substantially assisted the conduct that Lively contends was actionable FIHA retaliation. Instead, TAG's motion is limited to the argument that the conduct did not constitute employment-related practices. That is wrong for the reasons stated above. It is therefore undisputed for the purposes of this motion that TAG's conduct did satisfy the elements of FIHA aiding and abetting liability with respect to the retaliatory conduct that Lively actually challenges. Nevertheless, even if TAG disputed that it knowingly and substantially assisted a significant portion of the conduct on which Lively's retaliation claim is based, the record is more than sufficient for a jury to find in Lively's favour on that issue. Whether the elements of aiding and abetting are satisfied is ordinarily a fact-intensive inquiry. Viewed in the light most favourable to Lively, the record readily supports findings that TAG knew of her protected complaint and knowingly provided substantial assistance, but not encouragement, to a retaliatory campaign designed to damage her professional reputation and future career opportunities. At minimum, the evidence presents classic jury questions that preclude summary judgment. So, saying it should be denied. It wasn't a bad filing. It wasn't actually filled with bad arguments. But there was some contradictions there. And I just found Tag's motion more persuasive on the same, case citations. All right, guys, let me know what you think in the comments. I can do a video if people are still really confused. I can do a video kind of explaining this and comparing and contrasting the motion for summary judgment and this opposition in a little more detail, and we can look at the case law.